please the court. My name is Roy Diaz. I'm here for the appellant. I'm going to ask to reserve 5 minutes for rebuttal. We're here today, Your Honors, on a foreclosure action that was ruled upon in December of 2014. The lower court case was resolved by way of a summary judgment in favor of the defendants. In reviewing this case, we find that there are a number of issues that the court needs to address that warrant reversal. Primarily, in my opinion, the fact is that the issues below were not conclusively resolved as far as there being a genuine issue of material fact. There were a number of outstanding issues that I think that the court below didn't even address, because where the focus of the court below went was to 559.17 and as to whether or not the requirements of a condition precedent under that statute were properly addressed. In 2014, that issue was not an issue that had been properly vetted by an appellate court. At this point, that issue has been properly vetted by this court, although there are some
I'm
concerns.
on the minority side.
I know, there are
Mr.
some
Diaz,
concerns.
you know?
But we're in a different place. But before we even get to 559, let's just talk about the underlying case, and let's talk about the underlying issue, which is whether or not there was a genuine issue of material fact, and whether or not there was a basis for summary judgment at that point in the case. And, you know, we go back to this court's case in 1965, the Martise case, and that case, I think, establishes what the court needs to consider in order to find that there is no genuine issue of material fact. That case stands for the proposition that there cannot be a triable issue. The evidence and the court and the record has to be carefully scrutinized against the movement. If the slightest doubt exists, there is no summary judgment. That court identified the fact that when you're pleading and you're dealing with pleading, the process is not a I move, now you prove process. So the fact that there were still issues remaining unproven that may or may not have been conclusively established or rebutted by an affidavit or other form of summary judgment evidence, that doesn't eliminate the fact that there's a genuine issue of material fact.
I'm trying to understand, Mr. Diaz. And I know what you made that argument, but for pure summary judgment, if a movement files a motion for summary judgment, and that movement basically says, based on what's been submitted so far, there's really no genuine issue of material fact. And then if they file an affidavit basically setting forth their position and there's no contrary affidavit provided, are you suggesting that the court has to deny because there's a possibility that if this case goes further, other evidence could come in? You're not suggesting that, are you?
Not at all.
Okay.
No, the court has to look at the record. And in this case, for instance, there was still outstanding discovery. In this case, there was other pleadings.
It was their outstanding discovery, though, right?
Agreed. There was, but
so you had your client, Bank of America, whatever evidence it wanted or could have put in before the court to cast some kind of disputed judgment, it had it in its control and custody, or could have served subpoenas to have gotten it from third parties, or could have served its own discovery to get it. Didn't do any of that, correct?
It was outstanding, correct. That is correct. So that begs another question. So as we go through the process of proceeding in litigation, if a party files a motion for summary judgment, does that exacerbate the litigation? Does that put the other parties in a position where now they have potentially 25 days to prove their case? No, the case law doesn't support that.
No, but you do have you do have to be able to point out some kind of a disputed material fact that's
Correct.
at issue in the case.
And I would submit in this case there was a disputed material act. So the affidavit in support of the motion for summary judgment was an affidavit from the defendants stating that they did not receive a demand letter. The mortgage documents require a demand letter. Their allegation was they did not receive it. What has to be proven and what has to be established is whether or not that document was sent. The mortgage itself has language that supports that, and the case law supports that. That issue was not conclusively resolved at the time of the argument of the summary judgment.
And but if there was any dispute about that, your client could have put in a 2-line affidavit. First line identifying who's given the affidavit, and the second line says we did not send the notice. That's it, right? Now you've got we didn't receive it. They're saying, well, we sent it, and now you've got a disputed fact. How are the Vanskyhawks supposed to be able to aver that a required notice wasn't sent? I mean that.
But if you had a situation where the record below was that succinct, we would be having a different discussion. It wasn't that succinct. The record below, whether the appellant created that issue, created the record, didn't do enough for the record, but what we had below in this case was a record that was not that succinct. There still were other items in the record. There was an affidavit in the record. There were documents. There was in preparation of trial, there was an evidence list, a witness list that referenced demand letters, that referenced all of these issues.
All that could have been, I guess, to follow up with Judge Lucas, Mr. Diaz, it could have been very simply an affidavit saying, listen, we have these witnesses, this case needs to go to trial, these are like issues that are being disputed, but you're dealing with a silent record, and it's kind of, we get to see a lot of summary judgment cases come up
Right.
here, and typically we get an affidavit, there's a contrary affidavit filed, and then we get to determine, is there a disputed issue, a material issue, and depending on the case, but to proceed with a matter where you have one side, the other side is silent, but then the argument is, but we will be able to, deny it because we will show this.
Well, I don't necessarily agree, and this is the point I'm making to Judge Lucas. It wasn't that succinct. It wasn't that silent. It could have been less silent, and I'll stipulate to that. But it wasn't completely silent. There were other things in the record which take you to the standard. Can the movement establish that the non-movement cannot, under any circumstances, prove their case or rebut their case? And I think that in this particular case, the record was such that it happened, this judgment was granted too early. And I believe that the premise of granting the judgment at the point that it was granted was premised on 559-715. That was the thrust that I think the lower court took this into a final summary judgment under 559.
It may or may not have been, but you keep talking about, well, there was other record evidence. There were other things here. 1.510, for better or for worse, requires both sides to lay their cards on the table and point out to the trial judge, here's the summary judgment evidence I'm relying upon. Here's the summary judgment evidence I'm relying upon in order to defeat the other side's motion for summary judgment. At what point and where does this get identified, does this other record evidence that you're telling us now as an appellate panel cast some doubt as to whether or not this was proper for summary judgment? At what point was that evidence articulated and shown to the trial judge at summary judgment?
I believe it was shown at the argument, at the argument of the summary judgment, and the record that was before the court at the summary judgment.
So you stuff a record full of 10 depositions, you stuff a record full of a whole bunch of interrogatory responses, a bunch of extraneous things. You don't say a word about it in response to a motion for summary judgment, and you don't actually articulate other than to say, well, we've got these other depositions in there at the argument. That's going to be enough to defeat summary judgment for purposes of 1.510. That satisfies the language of 1.510 that requires specific identification of summary judgment evidence, which is a defined term in the rule.
No, and I don't concede that that's what happened here. But I do believe that under the rule, the summary judgment rule, the court cannot and is required to consider the record that's before it. So to the extent that the record before it does contain information that is parked before the court, it cannot be ignored.
So to take that a step further, then you believe that it is part of your argument that it would be the circuit judge's duty as part of every summary judgment motion that's brought before it to, regardless of what the opposing party argues, to then go back over the case file and independently review it to see if perhaps there was something that was missed that could create a material issue of fact?
I'm not saying that it imposes a burden on the judge to do a complete analysis of the lower court case, but I'm proposing that the judge should and is required to understand the record before the court before it considers a motion for summary judgment. Should the advocate opposing the summary judgment point those issues of fact out to the court? Absolutely. I agree with you that that is something that should be happening and should happen. But we can't ignore the fact that in this case, looking at the record that was before the court at the time, that there was adequate information in there, adequate documentation in there that would raise a genuine issue of material
What
fact.
evidence are you relying upon that was in the record at that time to support your proposition?
I'm sorry.
What evidence are you relying on to support your proposition today?
The argument regarding whether or not the demand letter was sent or received. I mean, that in and of itself.
That's counsel's argument you're relying on?
That.
Counsel's argument's not evidence. It's not under oath. It's
Oh,
not
no,
subject-
understood.
I'm saying what evidence that's before the trial court at this time are you suggesting to us that creates a material issue of fact?
The fact that the affidavit in support of the motion for summary judgment alleges that the demand letter was not received. And
So
under.
what you're saying is it's deficient in refuting all the possible hypotheses.
Correct.
But there's no positive evidence from somebody in your client's status that says, by the way, we sent the letter.
Correct.
Just make sure I didn't get confused here.
Correct.
Thank you.
Correct. So that leads us to the 559715 issue. So the court now actually concluded that 559715 applied as a condition precedent and was not met. I think that the case law on that has evolved, and I think it's clarified. There's been a number of cases that were presented in this particular case, but there's circuit court cases that predate the case law that has come out of this court in Brandeis and in Welker and in Hagstrom. And we believe that the thrust of the court's ruling in this case, supporting and granting summary judgment, relied upon this 557 argument, which we believe now has been concluded that it is not a condition precedent and wasn't a requirement, and we believe that a remand would be appropriate so that we can deal with those issues. I'll reserve the remaining time unless there's any other questions. Thank you.
May it please the court. I'm Mark Stopa, counsel for the Vanskyhawks. There are numerous reasons why I submit this court should affirm the order at bar. This case was pending for 40 months. 40. The summary judgment had been pending for 6 months. They had 6 months' notice of the dispositive hearing, and they filed nothing. No opposing affidavits designated, nothing in opposition. 1.510C, as Your Honor was touching on, is very clear. The adverse party shall identify by notice 5 days before the hearing any summary judgment evidence on which the adverse party relies. They designated nothing. So we went to court in a 40-month-old foreclosure case, that we stipulated, that had been set for trial, and we stipulated the trial shouldn't go forward so we could have this summary judgment hearing. So we were going to have a trial, but for that stipulation, and proceeded with the summary judgment hearing, and they had no affidavits in opposition. And our affidavit, mind you, didn't just say that the notice had not been received. It said that the notice wasn't given. And that's exactly what paragraph 22 contemplates, what paragraph 22 requires, and what our motion was predicated on, that the notice wasn't given. The lender had to give the notice.
Your argument is based on one section of a contract, correct? And your
That's
motion
correct.
doesn't mention the entire contract, does it?
That's fair.
Your motion doesn't have a word about paragraph 15 where it talks about how notice is given. Is that correct?
It does not.
So you are
That's true.
cherry picking in your motion the facts and the law and ignoring things. Is that correct? Because the rule says you are to stay with particularity the issues that must be decided, one of which is there's a contract. The provisions of the contract provide the following. Now, that's a legal determination for the trial court to say whether 22 and 15 are operable together or singularly. My concern is there's a false premise here. You set up a false premise that is only paragraph 22 is operational. I don't give any work to the quality of the legal work opposing you. Zero. I mean, they should have known what this contract said. They should have said things. They should have filed things. But under the rules, my understanding is you have to prove you can't win. And that means you have to prove they can't win. You have to prove that you complied with the contract between the parties. And there's nothing in your motion that I see says that they can't prevail under paragraph 15.
Well, respectfully, Your Honor, I disagree with that. Now, there is no DCA decision that's directly on point on this issue, but I think that when you have a summary judgment hearing in a 40-month-old foreclosure case where my clients come in and have both of them sign under oath, the bank lender didn't give us a notice, and there's nothing contrary to that, that shifts the burden onto them to come forward with something showing that a notice wasn't given. Because I do think that when it's undisputed that there was no notice given.
I concede that if the contract is silent on how to give notice, that there's a fair proposition there that they would refuse. But don't you first have to show that they can't prevail under the contract between the parties, and you've shown no evidence under paragraph 15 that notice wasn't sent, and that's how it's defined between the parties in their contract, how notice is to be issued. It says it right there in paragraph 15 in the mortgage? Notice to the borrower is deemed given when sent. Words to that effect.
I understand Your Honor's point. I've had this argument many times in the past. I respectfully submit that when we have an affidavit that shows that the notice wasn't given, and there's nothing contrary from my opponent, that it's undisputed summary judgment evidence that the notice wasn't sent. Showing that it wasn't given or wasn't received proves that it wasn't sent when there's no contrary summary judgment evidence. That, and I realize there's no DCA decision on that one way or the other, but I submit that that's how you should rule on this issue. And if you rule that way, you would agree with every single circuit court judge in the 6th Judicial Circuit who's ruled on this issue, and I gave you a notice of authority on that. I had every single one agree on that. And this was, most of these were in 2012 and 2013, but in Your Honor's old stomping grounds. Every single one agreed on that. Because why should we have to have a trial in a 40-month-old foreclosure case where they had 6 months' notice of the dispositive hearing, where we have affidavits that are on point that says there is no 22 notice, and they come forward with nothing to the contrary?
I'll answer your rhetorical question, because our Constitution says the parties are entitled to a trial until you, in a motion for summary judgment, can show under no facts can they prevail. And one of the facts in this is there's a contract between the parties, and the contract says notice shall be deemed given, and you have no evidence to show that they can't prove that at all. So therefore, that issue remains open at trial, and therefore it'd be inappropriate as a matter of law to grant a summary judgment.
Well, I respectfully disagree. Let me give Your Honor an example. Suppose this is a negligence case. If I'm the defendant, I file an affidavit in any standard personal injury case, traffic accident case, that says I wasn't negligent in this auto accident. The traffic light as I proceeded through the intersection was green. The plaintiff has some obligation, once I file that, to prove negligence with an opposing affidavit by saying, well, no, I saw your traffic light was red or something like that. If they don't come forward with that, then who prevails? Me. This isn't any different, okay? I file an affidavit that shows that the notice wasn't given. That shows, without something to the contrary, that that's undisputed. It's undisputed that it wasn't sent, because showing that it wasn't received proves that it wasn't sent. When there's nothing to the contrary, showing it wasn't given proves that it wasn't sent. You don't engage in like the hypothetical of like, take my same auto accident case. Well, maybe the traffic signal wasn't working correctly and it was green for both sides, and hypothetically, because it was green, could have been green for both sides, I'm not going to grant summary judgment for you or something like that. No, we trust the Postal Service. They get the job done. So when we have an affidavit that says we didn't get this notice, we didn't receive this notice, you don't engage in that speculative, well, maybe it was sent but wasn't actually received or something like that. It's undisputed. In a 3.5-year-old case, it's undisputed that there was no notice given. You don't, just like in that traffic accident case, you wouldn't assume that, well, maybe the traffic light wasn't working right or something like that. They have to come forward with something. And they didn't. And that's why every judge who heard a foreclosure case in the Sixth Circuit agreed on this fact pattern. Every one.
I think, Mr. Stope, if I were to take that point, and not crazy about hypotheticals, but to work with that hypothetical, I think the argument might be more along the lines of your affidavit was not the equivalent of saying I had a green light, because the central issue in the case was whether or not the notice had been sent, not whether it had been received, okay? So your hypothetical would probably, a closer hypothetical would be something along the lines of, I did not see a traffic signal there, and that's it. What do you do with that situation? Because I think that's a little bit of a closer analog to the situation we have before us, which is that your client is saying, hey, I never got this, but the contract requires only that it be sent.
I think I understand. I'm not crazy about hypotheticals
Yeah,
either,
yeah.
But I think I didn't see a traffic light there.
What you're saying is, look, I think if I understand your argument is, my client's affidavit says we did not receive this notice, and the only inference that can be drawn from that is that, in fact, it was never sent. Because for precisely the reasons that you've argued and that we've been talking about with opposing counsel, which is that Bank of America put nothing in the record to indicate that they in fact sent the notice. So I think if I understand your argument is that by virtue of my client's providing affidavits, say we never received this, therefore the inference that should be drawn is that it wasn't sent. Am I understanding that argument correctly?
I think that's one way to couch the issue. I think that's one fair way to...
How else do you couch it for purposes of summary judgment?
It's not just received and sent, it's also give. And I do think there's a difference between give and receive. I don't acknowledge it's just a sent and received, because 22 says give, and our affidavit does say give. So I think you're comparing sent and give.
So your clients went the step further then and said not only... But we are prepared under oath to say that we have knowledge that Bank of America did not give this notice.
Right.
And that is what you would hang your hook on, correct?
Yes, because that's exactly what the affidavit provides and what 22 provides. Give the notice.
And if they were incapable or incompetent to be able to provide such affidavit, it was incumbent upon the bank to provide some kind of contrary evidence to say, you know what, these folks have no way of possibly being able to aver that the bank gave it. You should only look at the evidence that they could positively aver to, which is that they didn't receive it. But your point would be, if I understand it, is that, look, they didn't challenge that aspect.
2 points. First, under Hall versus Talcott, our affidavit that they didn't give the notice shifts the burden to them. It was sufficient to meet our initial burden under Hall versus Talcott. And then second, they had an obligation, if they thought that the standard was not give, to designate summary judgment evidence under 1.510C. They didn't do it. It's very clear in the rule. Shall identify notice. Shall identify notice. So when I say the standard is give, if they think it's something otherwise, they have to say so. They have to designate that. You don't just get to come up and argue it at the hearing for the first time, because then you get to the example that Your Honor asked him, that I spelled out in my brief of you 4 circuit judges to dig through the entire record to try to figure out, well, is there an issue of fact or something, even when they didn't designate anything?
So if I may, Mr. Stoppa, to try to address Judge Casanueva's concern, as I hearing your exchange with Judge Lucas and in response to Judge Casanueva, by virtue of the affidavit that your clients have prepared, the affidavit, even though it dealt more with the paragraph 22, in essence, by implication, also addresses paragraph 15, because your clients indicated that they did not receive, they did not give, and therefore by implication, you could come to the conclusion that notice was not sent.
Well, I think that's a fair implication, but I also think it would be fair to say that you don't even ask the question on whether the notice was sent, because the issue as framed was the notice given, and that's what 22 requires, and if they wanted it to be framed as sent, then they should have designated paragraph 15 as summary judgment evidence. So that's my twofold response to that issue.
I understand that, but at least because Judge Canswaver raised that concern, and I want to make sure that we've dealt with that concern.
Sure.
Okay.
And does that answer your
It does.
question?
It does.
Okay. And so to me, it's appropriate to affirm based on paragraph 22. And I also think it's appropriate to affirm based on preservation. I want to be clear to talk about preservation, okay? Now, before I get into the merit of the 559 argument, on preservation, I did a notice of supplemental authority that cites a Florida Supreme Court case called Dober from 1981, just a couple weeks ago. And they specifically hold that preservation is required in the summary judgment context. If you don't raise the particular issue in the summary judgment context, it's not preserved. Here, I submit that my opponent did not raise the particular issue in Brindis of that 559 is not a condition precedent to foreclosure. The closest that they come was the portion of the brief where counsel said, used the term precedent. They didn't even say that it was a condition precedent to foreclosure. So you can't reverse based on Brindis by concluding, well, it's not a condition precedent to foreclosure, when they didn't even argue that at the hearing. It's not even there. So I don't know as I read that transcript, maybe they were trying to say that, or maybe they intended to say condition precedent to foreclosure, but it's not in that hearing transcript where they said this is not a condition precedent to foreclosure. And without that argument, it's certainly not specific. Ailes versus Boemi, what do they require? Florida Supreme Court, specific objection. When they don't say with specificity, this is not a condition precedent to a foreclosure action, the giving of this notice under 559, they did not preserve the issue, and you should not reverse on that basis. And another reason, even if you disagree with that preservation argument, that you shouldn't reverse on this basis, is that Brindis was in the trial context, and it dealt with who bore the burden of proof at trial, such that is 559 a condition precedent at trial. And so a couple points on that. One, Your Honor, I realize you were in the minority at the time, but there's 2 new judges now. Take them to lunch. Convince them on your position. The alternative, sorry, I had to say that. The alternative.
Interesting lunch, huh?
I'd love to participate, but I have to ask that you just do that on your own, I guess. The other thing is, this is, going back to my major point here, this was not a condition precedent issue. We weren't in the trial context. This was the summary judgment stage. We bear the burden of proof at summary judgment. So when I bear the burden of proof at summary judgment, it's not, well, is this an element they have to prove in their prima facie case at trial? It's we bear the burden like a defense. And what's the case that deals with 559 as a defense? Amstone. That's Your Honor's decision that specifically says in the summary judgment context that 559 was a legally sufficient affirmative defense, and this court reversed a plaintiff's summary judgment because the lender did not disprove a 559 affirmative defense in the summary judgment context. In so ruling, this court necessarily said that 559-715 is a legally sufficient defense. Now, I submit that not only is binding precedent in this context, but it has to be binding precedent, because if you say that it's not, that you can't sue, as the 5th ECA has said, that you can't sue for a 559 violation, and it's not a condition precedent, as this court has currently said in Brindis, then what is it? How do you enforce the remedy? What's the remedy for a consumer if this is violated? There has to be a recourse, because there's lots of cases, including this court in Reed and State versus Good in my brief, makes clear the legislature doesn't write meaningless provisions. So how do you enforce the notice requirement in 559-715 if you can't sue, if it's not a condition precedent, and it's not a defense? There has to be an answer. There has to be some enforcement mechanism, especially in the consumer protection context. So the answer is you treat it as a defense. If it's not going to be a condition precedent, if your lunch doesn't work, then treat it as a defense. As this
the trial court spoke on this case, if I recall, she gave her the history of this. Refresh my memory. When she ruled, she said this was a condition precedent, right?
This was
rather than a defense. I'm just trying to make sure I remember her words.
Yes,
Okay.
she was, and at the time I was arguing this as a condition as a condition precedent. But I think
my concern is this: in Welker, didn't we say it's not a condition precedent?
Well, in Brindis, you said that
I'm
it's
talking
not
about
a
Welker at 194, where this court, Judge Black writing said, as this court has previously held, providing a notice described by section 559.715 is not a condition precedent to foreclosure. And my concern is if that's what the judge ruled, that this is not a condition, that this is a condition precedent to foreclosure, can I ignore that?
Tipsy Coachman. It cannot be a condition precedent, but it can still be, you can still treat it as a defense, which is really what it was arguing at, because it didn't have to be an element of the prima facie case at trial if it's a dispositive defense, like it was in Amstone. And this has to be a dispositive defense. Otherwise, you take a consumer protection statute that has a notice provision and you ignore it. I'm sorry?
And it'll protect nobody.
Exactly. You know, like I thought of an example here.
You've got a cause of action. If it's not a condition precedent, then there's only one thing the other thing can be in order to enforce a legislative structure.
Exactly, thank you. And, you know, I thought about how you can reconcile all this with this court's Hagstrom decision as well, which my opponent mentioned. There's a simple way. In Hagstrom, it's a trust case. And in a trust case, the servicer and the holder are not the same entity. The servicer and the holder are not the same in a trust case. In a case like this, the servicer and the holder are the same because it's not a trust case. And when you have a fact pattern like this, there has to be an enforcement mechanism for a consumer. Why? Because let's say, as an example, that I'm the consumer and I have a check I'm ready to reinstate. I have a check. I want to pay my lender. I don't know who it is. I can't contact anybody. I don't know who it is. And because I haven't gotten the notice of assignment of the debt, which this court has construed as the notice, even if you construe that as notice of the right to bill and collect, I haven't gotten the notice. All of a sudden, I get sued for foreclosure. More fees and costs and interest are added on. Now I see, oh, it's Bank of America. They never gave me the notice. You're telling me in a context like that where you have a statute that requires that a notice be given 30 days before any action is taken, that the lender can just get away with not giving me that notice that says, here, we're the party that you have to pay. They can get away with it and there's no recourse to the consumer. There has to be. There has to be a recourse. And that's the way that you could reconcile Hagstrom and Brindisi. Even if you're not going to change Brindisi, you can reconcile Hagstrom and Brindisi by saying where it's the holder. And I actually have a motion for rehearing pending on Hagstrom that makes this distinction.
I'm curious, Mr. Stowe, because I know you deal a lot with this. Have you gotten any sense of whether the Florida Supreme Court has weighed in on this or will be weighing in on this?
You know, I'm trying. On Brindisi, they didn't accept jurisdiction with no explanation. I can say that on Quinion, that was the pleading decision on how to plead 559, that I brought that up on conflict jurisdiction, and that's been pending there for 3.5 months, and they haven't kicked it out yet. So I'm hopeful that that'll get there in that context. That's the only answer I have at this point.
You need to make sure you get to all your issues before you run out of time.
Oh, sure. Thank you, Your Honor. So I submit that this is that it's appropriate to affirm, and can I ask how much time I have?
That's the question, because this machine didn't start when you started. Yeah, and I'm trying to figure out how much before we had our first conversation had gone by. That's when I first noticed. So I assumed you were about 5 minutes in, so we're at about 14. That'd be 19. So assuming that I'm wrong, I'm going to give you a couple extra minutes just in case. And we'll blame the timekeeper rather than the machine, because I could have sworn I hit the button.
I always like to argue until I'm told to stop, so that works for me, Judge. So it's appropriate to affirm here based on the paragraph 22 issue. It's appropriate to affirm here based on preservation, even if you disagree with everything that I said about 559-715. They didn't preserve these issues here. They didn't preserve the specific objection that 559 is not a condition precedent or a defense to foreclosure. There was a lot of discussion about, well, is foreclosure an action to collect debt? That's a lot of the discussion from the trial transcript. But if you look at this court's decision, like look at Brindisi, even in Brindisi, this court didn't say that foreclosure is not an action to collect debt. And I submit there's no way that this court can go there. There's no way you could say that foreclosure is not an action to collect debt. For instance, if you look at all of the federal court decisions, you have the 3rd Circuit, 4th Circuit, 6th Circuit, 10th Circuit, 11th Circuit are all holding that foreclosure is actions to collect debt. For instance,
Not to create this big gap.
I'm sorry?
Otherwise, the court said it'll create this big gap.
Exactly. For instance, in one of those 11th Circuit decisions, we'll call Burster, the fact pattern there was the mere sending of a paragraph 22 letter. Just that is an action to collect debt in the FDCPA context. Here you have an entire lawsuit, and I'll borrow one of Judge Silberman's arguments that I love that I incorporate now into these, is that what is foreclosure? It starts out with a complaint that demands an amount of money. And then if the plaintiff prevails, a final judgment is entered that awards some amount of money. And only if that amount of money is not paid by the borrowers does a sale then get scheduled. There's no way to characterize that as anything but the payment of money. And one of those Sixth Circuit cases in the federal jurisdictions say essentially that. There's no reasonable dispute that foreclosure is not about money, and Your Honor quoted that in the Brindis decision. So, or in your Brindis dissent. So, and the Brindis majority didn't disagree with that. So my point here is the only argument that my opponent really preserved in the 559 context is one that's wrong. The issue that they might be wrong on, or might be right on, given the current state of the law, is the one that they didn't preserve. That it's not a condition precedent or a defense to foreclosure. So. And as you think about this, Your Honor made a point, you give zero credit to the lawyering. There shouldn't be a reward of reversal when it's this bad. 40 months, 6 months notice, no affidavits at all. And, I get all the time in these cases, deadbeat borrowers, Ostopa's just trying to delay. I'm the one in here going, let's have the case be heard on the merits. I'm the one in here going, we have an affidavit, let's hear the case on the merits. Can you imagine this being reversed? If the roles being reversed, if I come in here after 40 months and say, well, I didn't get to take discovery, but, after 40 months, you should have reversed the summary judgment, you'd be kicking me out of here so fast and PCAing that my head would spin. Don't make it be different just because they're the lender. You wouldn't be reversing for me on that fact pattern. So I ask that this court affirm and that you can write a decision that says all those Sixth Circuit judges who ruled the way that I did that I asked them to in 2012 and 2013 were right, because they have to come forward with something. It does meet the initial burden under Hall versus Talcott.
And you said, and you would keep on going until someone said you had to stop. We're there.
Okay. So this court should, for these reasons, affirm the order. Thank you very much.
Hold on, I'm going to make sure the right works again. All right, please begin.
I will not presume that I'm getting an advantage because I represent a lender. Let me just start with that. This is really an interesting case, and it's really an interesting position.
Well, let me ask you this question. At some point, the burden would shift to you to put on some evidence, and as I understand, by you, I mean your client, not personal.
I know.
They did nothing, and arguably you could make the contention that the movement said, I'm placing you on notice that in my motion for summary judgment, paragraph 22 says given, and that's the word I used for my client, was not given to me, and you stood mute. Is that enough to make you respond?
We didn't really stand mute if you think about it, and again, you look at the record. There was an allegation in the complaint that all conditions preceding were met. Okay.
This is an evidentiary proceeding for summary judgment to determine whether or not the right to trial is necessary. So the only thing that had to happen was somebody, as Judge Lucas pointed out, needed to file an affidavit out of abundance of caution, if not required by law, saying, we sent it according to our records. And pursuant to paragraph 15, we've complied with the contract. And yet, the bank remains silent. So legally, though, may not be necessary unless the right has been triggered that you have to respond. So that's why my question, were you put on notice that you had to respond under the rule?
No. And the reason we weren't put on notice that we had to respond under the rules is because the burden didn't shift. And the reason the burden didn't shift is what was discussed during my opponent's argument. It created an inference, not a fact, not an undisputed fact. It created an inference. There's an affidavit that says that we didn't receive it. That creates an inference, not an undisputed fact.
And at what point did someone tell the trial judge, by the way, Judge, it's our contention that paragraph 15, the contract between the parties, defines notice? Anybody alert the trial court to that?
No, I don't believe that during the argument that issue was delved into at that
Isn't
depth.
that the simple response? Paragraph 15 is part of, like paragraph 22?
Well,
it's part of the contract between the parties.
No.
Judge, you can't grant them the motion because paragraph 22 says, hey,
No.
once it's sent and they don't have a scintilla of evidence on that issue.
Right.
Isn't part of preservation alerting the trial judge to the issue so that a specific objection, the trial court can make a ruling and then it's preserved for our review? Is that not correct?
Sure. But the terms of the mortgage were argued in the case below. The terms were argued below. So that it wasn't a situation where the plaintiff went into the motion for summary judgment proceeding and stood silent. That's not the case.
It wasn't, because the transcript all reflected there was a big debate as to whether or not this was a debt. Nothing. There was at least, and please, guide me if I'm wrong. the transcript didn't reflect anything regarding the notice issue. None of that was argued before the court.
And that's what I pointed out earlier in the case, because the thrust of the ruling and the thrust of the focus was this 559 issue, which, by the way, I think is disingenuous to argue that wasn't preserved. When you look at the transcript, it was vetted, it was argued, it was feverishly argued, I think, in one of the positions in the transcript.
Assume you're correct and that the trial court erred. There's a second basis, right, on paragraph 22, granting summary judgment, that you failed to comply with that. So all the appellant has, the appellee has to do is prevail on one of the two theories in order to sustain.
But the judge didn't rule that the paragraph 22 was insufficient. There was no ruling that it was an inadequate notice. So that wasn't where the court went with this was.
Is that what the motion said and the order said granted?
Well, the court found. I mean, you can't ignore what the court stated. The court found that the issue the thrust issue here was the 559 position, that was a condition precedent, and that's what the court found, and that's what the court ruled on. So I think the danger here is that we're finding ourselves in a position where the argument being presented is these cases have to be litigated at summary judgment, and if the record doesn't support summary judgment at the very high standard that summary judgment has been established to be, that summary judgment is appropriate. And I think that now we're receding from case law in this district.
Mr. Diaz, no, I want to make it quite clear. We're not suggesting anything contrary to the case law. What the case law requires that if a movement prepares an affidavit in support of summary judgment, then the other side needs to come forward with anything that would suggest that there's a material issue of fact. And if the other side remains silent, an appropriate conclusion would be maybe you're acquiescent, maybe you agree, maybe that becomes a non-issue. So that's the concern that we have, is based on this record here, it was surprising, no contrary affidavit that was submitted that would create that issue. So the fact that the trial court before Brandeis came to a different conclusion, she could still be right, but for the wrong reason in light of the actual posture of the case. That's what I think, based on our questions, is what we're concerned with.
And my response to you would be that the affidavit that was presented in support of the summary judgment did not conclusively establish that the plaintiff did not meet the requirement of sending the demand notice. And the fact that it wasn't received does not conclusively establish that. If the letter was lost in the mail, if the letter was arrived at the property and was somehow thrown out by accident, there was no evidence before the court that the plaintiff didn't send.
It doesn't matter if it got lost in the mail. There's decisional law that suggests in certain of these contract acceptance is when it's mailed.
Correct.
Under the specific terms of your mortgage, paragraph 15 says once it's mailed.
Correct.
So it doesn't really matter the hypothesis if it got lost in the mail. Once it's mailed by first-class mail, I believe is the language in paragraph 15. That's all the bank had to show.
And the affidavit in support of summary judgment did not conclusively establish that it was not mailed.
I understand. That's why I asked the first question. At what point does your obligation to respond under 1.510 triggered? Because had you responded that way, no one would be here today, arguably. Or we'd be here on different issues.
And my response is when the burden shifts, and based on the affidavit that was filed, the burden didn't shift. So I asked that it be.
That's kind of a risky theory of your defense, isn't it?
I really don't think it is. I mean, we're looking at summary judgment proceedings. We're looking at how tight a record has to be, how tight the evidence has to be, and in this case, it wasn't. The standard's very high. So we would ask that it be reversed and we go back and continue down the road. Thank you. Thank you.
Thank you both.
We have one more to use, right? Fair enough. We're going to take, we finished the 9:30 session. For those of you who are 11 o'clock arrivals, I will tell you the good news. One of the cases has continued, so we only have one more remaining on our docket today. And we'll come back in about 10 minutes and take care of Cohen and Hearn, if I pronounced everybody's surname correctly. Thank you. We're in recess.